All right, this is case number 22-242-881. This is Valerie Daltrey versus Unique Tire and Repair. A matter set before the court on for a pretrial conference at this time. It looks like in setting this matter, it looks like in setting the matter, the court had previously issued an order. And that order was scheduled certain events regarding this matter. All right, your appearance for strike that. Do I have Valerie Daltrey on this Zoom?
Yes, sir.
All right. Good morning to you, ma'am, and happy New Year to you. Are you representing counsel this morning, ma'am?
I'm sorry.
Represented by an attorney this morning?
No, sir.
All right, thank you, ma'am. For Unique Tire and Auto Repair, your appearance at this time.
Good morning, Your Honor, and Happy New Year. Lamise Nazal, P84725, appearing on behalf of Unique Tire.
All right, thank you, Madam Counsel, and Happy New Year to you as well. So go ahead and update me on where things are. I know that I set a scheduling order in place at a previous time, Madam Counsel, if you will.
Your Honor, unfortunately, we were unable to resolve this case prior to today's date. We did have a discussion regarding the facts of the case. There were some questions asked. Ms. Daltrey did answer those questions. However, she did indicate that she sent the court some documents. She did not send me those documents. I asked her to send me those documents. She said she was not going to send me those documents and that the court would provide them to me. I just would like the court to advise Ms. Daltrey that she is under the same standard as an attorney in this case, even if she's representing herself. So whatever documents that she does have in her possession that I requested would need to be provided, even if she sent them to the court.
Thank you. Well, I would indicate under the court rules, Ms. Daltrey, you do have to submit any documents that you might want to use at trial or in the advancement of this matter. You have to share that with the other side. The court can't engage in any ex parte type of activity, meaning that the court can't engage in documents that one party has presented to me without the other party having access to that. So even if counsel on behalf of her client wanted to send something to the court, she would have to send that to you. Otherwise, I'd have to ignore it. It can't.
Okay, I did send her the pictures of the car. And the other information was from the fire department. And she's saying I didn't answer the information, but whatever she asked me, I told her that I had sent you the information with the reports from the firefighters. She asked me to send it to her. I said I had sent it to you.
No, your first of all, until you hear me conclude talking, try not to interrupt in that because it helps the flow of things here when one party is able to complete what they're saying, and I will give the same benefit to you. Don't interrupt, and as you're talking, I won't interrupt unless it's absolutely necessary. Whatever document you may have sent to the court is not a document that I'm going to pay any attention to until both sides have that document, because the law doesn't really allow me to do that unless someone files some type of ex parte motion that has some deep secret to it, and they're requesting the court to deal with it undercover under special rules. Otherwise, the other party has to receive whatever you send to the court. So you have to do it that way. If it's going to come out, it's going to be something that's going to come out anyway, and that's kind of the thought behind those kinds of things. That whatever a party has to share, they intend to share at trial. The discovery period is that period in which the other side has the right to discover that, to know what information is going to be presented. And that's true also with the defendants in this matter. If they intend to present something at trial, they intend to bring something to the court's attention, you have the right to know that before trial. You have the right to know that before the trial date shows up. And that's what the discovery period gives the parties a right to request under the court it should be shared, so that you're not surprised at trial, so that something is not presented that you didn't know was going to be presented at trial. All right, so I'm going to need you to get whatever this information is over to the plaintiff, sorry, that defendant. Anything you intend to present at trial, I'm going to order that it be shared with the other side. If you want to present it to me, if you want to use it as evidence in the case, then you've got to present it to the other side. Got to be sure that they have that. And that's also true with Madam Counsel. I know that I have an order out there, and that is oftentimes triggered by a request. But I will simply go ahead and order down that anything that the defendants intend to use or raise at trial, or any documents they intend to present, that they would make those documents available to you, Ms. Daltrey, as well, so that you will know whatever they intend to offer by way of proof at trial. It works on both sides. When there are attorneys involved, the attorneys, of course, know, they know to request certain things. Sometimes if you don't request it, then they don't have to turn it over. If you request it or the court orders it, then they got to turn those documents over to the other side. All right, so I want to go ahead. Looks like you're not going to be able to get this resolved, or you haven't so far. So I want to go ahead and set maybe a trial. It might help if this matter goes to some type of mediated potential solution. So I see that the claim here, I believe, is a claim for some $6,500. The claim is for $6,000, and this alleges negligence and ineffective repair that resulted in the vehicle catching fire and being that's the nature of your claim. Is that correct, Madam? Is that correct, Ms. Daltrey?
Yes, sir.
So there's been some discovery in this matter. Let me ask you a question, Ms. Daltrey. How long after you had the vehicle repaired at Unique, how long after that time did the vehicle catch fire?
It was about maybe, I guess, about a couple of months. I had tried to get them to fix it. Then they wouldn't fix it, so I had it sitting for a while. And then I did talk to an attorney. I sent you that information to try to get them to talk with them. And that was like in April.
Okay, got it. All right. So yeah, it seems like it's a contested enough issue, and I see where obviously the closer that the emergence of the fire is to the event, that simplifies things a little bit. But you've also indicated that in the interim, you were making efforts to have them to comply with the warranty requirements. All of that is a part of this. All right, so Madam Counsel, your thoughts in this regard?
Your Honor, there are two situations where Ms. Daltrey brought in her vehicle, which is a 2007 PT Cruiser, into the shop. That's my client's shop. The first time she brought it in, they ran a diagnostic test, and the results indicated that the engine was blown and that there was a new engine needed to be installed. This was relayed to Ms. Daltrey. Ms. Daltrey informed the representative at the time that she was unable to afford the one lump sum payment, so they put her on a payment plan. They ordered the engine, and when the engine came in, they put it in. The vehicle could not leave the premises because the engine was blown. So they replaced the engine, and she left with the vehicle. A couple months later, she called them and said, "Hey, I'm still having problems with my vehicle." They said, "Bring it back again, and we'll see what's going on." When they ran a diagnostic test, the engine was completely fine, but the PCN, which is a computer portion of the vehicle, needed repairs. They indicated to her this. She was upset. They said, "You won't have to pay us the cost, but you'll just have to pay for the replacement part." She refused, and she took her vehicle and left. That is what happened during this transaction.
Do you know how, Madam Counsel, do you know how long after that particular discussion that you've described, that is, that there was an indication of a part needed in a refusal to act upon that? How long after that, to your knowledge, did the vehicle catch fire?
I'm not sure, Your Honor. I'm going based off of the indications of the plaintiff. That was a couple of months. My clients were unaware until they received the small claims affidavit from Ms. Butsy.
All right, so what I'm going to do is I will go ahead and set this on for a trial. In the interim, I'm going to require that any and all information that either side intends to present at trial, that you make sure that you turn information over to the other party, and you must do so, otherwise such information will be precluded. You won't be able to use it. So you got to present or submit that information to the other side on or before the 20th of January. That's the cutoff date. And make sure that if you're going to use it at trial, that you share it with the other side. Otherwise, if it's not presented by via mail or some other drop off, then you will not be able to use such information at trial. So make sure that you get that information not later than January 20th. I'm going to go ahead and set a trial date in this matter, and I'm going to set the matter on the trial on the 23rd of February. 23rd of February, 2023, 2/23/23. And that trial is going to commence at 11 o'clock a.m. That's on February 23rd, 11 o'clock a.m. Matter set on the trial. Obviously, you should still continue to work towards trying to resolve the matter. And a part of the challenge in these kinds of cases is causal relationships, how one dot connects with another dot. The law requires that there be a proof by preponderance of evidence as to causal relationships. It almost seems that in this kind of situation, there would have to be an expert describing exactly what the nature and origin of the fire was. An expert would also have to causally relate to the fire to something that was negligently done by the plaintiff in this matter. Those are heavy burdens of proof. That's why I mentioned that. And it makes it a situation where the most reasonable thing to do is to find an accommodation, to find a middle road where the parties can meet. A lot of times, even if something was caused by a particular event, depending on the circumstances, it can be difficult to connect it to that event, particularly where you're talking about the further you get away from one event, the more difficult it is to prove the other event, and the more likelihood is that you will need an expert to be able to establish that. That's a part of the challenge that I see. It may be something very, very simple. I don't want to raise that because sometimes if you can reach a resolution that involves both parties compromising some, that may be a better way of avoiding a proof requirement that may turn out to be a result that is not the best result for anybody that's involved. Because if you talk about something catches fire a substantial period of time beyond the event of the repair, then you've got more and more of a difficulty of that event, of it being established that that event was caused by what was done on a particular day. And when you start talking about automobiles, you start talking about an engine, you start talking about driving, operating a motor vehicle, and something occurring at some point, being able to establish that that is by virtue of the negligence that someone else did 2 months ago, that's difficult. You can do it, but it's difficult. Now, the only reason I talk about that, not because I made up my mind anyway, I haven't heard any proof in this whatsoever. The only reason I'm talking about that is because if there's any room to find to compromise and reach a resolution between the parties, you probably want to do that. Now, do I have an interest in this case? Of course not. I don't know Ms. Daltrey. I don't know the lawyer involved. I don't know the company involved. But of course, you guys know what I do know. I've been a judge 30 years. Man, that sounds crazy. But anyway, I've been a judge 30 years. I've tried thousands and thousands and thousands of cases, and so I know evidence. I know how evidence works. I know how people can be in the right and still end up losing because of proof. So I want you all to think about that. And sometimes people win because someone else is not able to establish something that they should establish, and therefore someone wins who maybe should not win. All of those are factors when you start talking about a window that is called a trial. And in that window, there is a burden of proof. And that burden of proof requires certain elements to be established by a preponderance of evidence. And so you have to think about those kind of things. The only reason I take time to talk about that is because of my broad experience in dealing with cases, and especially dealing with automobile cases. You're talking about a vehicle that's 18 years old. There was a service before that replaced the engine, and then I think you interrupted me. I heard a sound. Ms. Dalton. Okay. So yeah, I wanted to say that now. The parties are free to advance the cause the way that you want to. I'm going to allow you. I've already given you a trial. I'm going to allow you to have your trial in front of me, and I'm going to allow you to present everything that you want to present. You will get the fairest trial to present everything that you want to present. But also, you want from me, either party that's involved in this, what you want from me is you want my honest assessment based upon my experience about what the trial difficulties may be or may not be. If you don't want that, then that means that you're not really smart. 30 years of doing this and many other years prior to becoming a judge, you certainly want that information. Take that into consideration. And if you find a way to talk through this and compromise, find a way that you can get it resolved, then do it. If you can't, then you still have the trial. Come back and do the trial. The court will hear it, decide, weigh the evidence out. In whichever way the evidence points, that's the direction that I have to decide the case. That's what my sworn duty is. Whatever way the evidence go. All right, so you got your date. I took a little bit of time, and thank you, Councilman.
Your Honor, I'm sorry, before we sign off, to file an MSD, should we also have the MSD filing on February 23rd?
Yeah, if you have a motion for summary disposition before the court, I will hear it on the date of trial. As long as you give the other party in this matter at least 14 days to respond to that motion. Motion for summary disposition is a claim in a motion requesting that the court, a claim in a motion that there is no genuine issue of material fact, that the evidence of the case is not sufficient enough to go to a trial, and that the court should decide the case on the motion. If either party files such a motion, my duty is to rule on that motion. If that motion is filed, the opposing party under my court order has 14 days to respond. So if this Nasal files a motion for summary disposition, Ms. Daltrey will have 14 days to put something in writing opposing that motion. And then I will hear that motion on the date of trial. I'll hear it on the date of trial. And part of the challenge here always is that when you, whenever a person has a case in front of the court, whether they are represented by an attorney or not, the law holds every party to the same standard as an attorney. And that's why I try to explain stuff as well as I do, because I know that Ms. Daltrey is not an attorney, but I know she doesn't necessarily need an attorney to advance this case. But what she does have to know is what the rules are. And so if counsel files, then you have to put something in writing in response to that motion, and you have to do it within 14 days after you receive the motion. And then I'll read the motion, I'll read Ms. Daltrey's response, and I'll decide the motion on the 23rd. Also, if Ms. Daltrey files a motion, then Ms. Nasal has to respond to that within 14 days, and then I will make a decision on her motion. Either party can file a motion. A motion is just a document requesting that the court do something based upon the court rules. So, Judge, I'm asking that you dismiss this case because the court rule says X, Y, Z. Or Judge, I'm asking that you give me a judgment right now against the defendants in this case because they don't have anything to defend against the claim that I'm bringing. That can be put in a motion, and the court has to decide that motion. And I talk about that only because I know that Ms. Daltrey is not a lawyer, but those rules are very simple. They're very simple, and if you follow those rules, then whatever you present to the court will evaluate it, assess it, and then I'll make a decision as to what the outcome should be. That's my part of the job, is to make a decision. Your part is if you want to present something to me, we call it a motion. In the common language of the day, oftentimes it is a request to the judge, but formally it's called a motion. It could be a motion to dismiss, it could be a motion for judgment, it could be any kind of names that you can put to a motion for something. It's simply a request that the judge do something in a certain way. And if a person files that, I will set it for hearing. Today, I'm setting it on the same day as the trial date. I'll hear it on the 23rd. If the motion is granted and is positive, meaning that it resolves the case, then that means that there won't be a trial. If the motion is denied, then the trial will proceed on that date. Any motion that's filed on that date. All right. Thank you very much. I will see the two of you on the 23rd of February. I wish I could say it sooner, but I got so much going on. That's the earliest date I can give you for the trial date, the 23rd of February, and that's going to be at 11 o'clock. All right, good day to the two of you, and I wish you well. See you at the next meeting.
Thank you, Your Honor. Bye-bye.
All right, thank you for your patience on Beaumont versus Amanda Lynn Bruma. I believe it's 2193751. The matter is before the court set on for a hearing on today's date. Your appearance for Beaumont, if you will, at this time.
Yes, good morning, Your Honor. Happy New Year to you as well. For the record, my name is Rex Lonnie, Lany, P24710, appearing on behalf of plaintiff. This is a case, Your Honor, there are actually two defendants. One of them is Miss Chappell, and the other one is Miss Balmer.
All right. Oh, yeah, I do see Jasmine Chappell is the other defendant in this matter. Thank you, counsel.
Thank you.
Do I, on the Zoom, Buma, first, Baumia. If you are on the Zoom, let me hear from you, ma'am. All right. Do I have Miss Chappell on the Zoom? Let me hear from you, Miss Chappell. Do you hear?
Yes.
All right. Good morning to you, ma'am.
Yeah, my last name is Chappelle.
Chappelle. All right.
Yeah.
I should have known that. I had a high school classmate who was Chappelle. All right. Thank you, Ms. Chappelle. All right. Good morning to you. All right. So it looks like there has been a motion filed in this matter for a summary disposition. And Ms. Chappelle, you received a copy of that motion from Mr. Burke's office. Is that correct, ma'am?
I don't even know what a motion is. The only thing I received is this paper right here telling me to log on to Zoom.
You received a notice from the court giving you the Zoom direction. But it looks like there was a motion that was filed where the plaintiff in this matter is asking the court to grant judgment in this matter, and they're indicating that there's no genuine issue of material fact. It looks like that's the issue that is being raised in this case. Did you receive that, ma'am?
No, not that I'm aware of, no.
All right, and let's see. Okay, all right, so I know that you received a notice from the court. Unfortunately, on our register of action, we didn't have Ms. Chappelle on this matter. And I'm looking to see where you might have sent the motion, counsel. I'm just taking a look here. And you can enlighten me, if you will, counsel.
Yes, thank you, Your Honor. I am appearing by substitution, and so my information is basically the same as the information that you have in the court records.
All right, thank you, sir. Just one moment.
Thank you.
All right, so what I'm not seeing is a I am seeing a certification of mail to Miss Seamster or Miss Buma at a address in Taylor. Let's see. Okay. I'm not seeing where there is a certification or proof of service as it relates to Ms. Chappelle on Tracy in Detroit. So it looks like the motion
Okay.
was filed, and there is a proof of service attached to the motion regarding defendant number 1 in this matter.
Ms. Palmer?
Sorry, sir. You said something, Counsel?
Yes, Your Honor. There was a proof of service for Ms. Palmer.
Yes.
Thank you.
But I don't see one for Ms. Chappelle.
Okay.
All right, so I'm going to go ahead and reset the motion as it relates to Ms. Chappelle. There is a proof of service and a notice that was directed from the court that did go to Ms. Buma in this matter, and she's not appeared on today's date.
Yes, Your Honor. Your Honor, if it pleases the court, may I request a judgment? We have the amount that is due. It's $1,500 plus costs.
All right, the court will grant judgment on your motion by virtue of the fact that Ms. Buma did not appear, although she received, at least based on the proof of service and the notification from the court, she received the documents that would require that she be in court on today's date. Accordingly, the judgment will enter upon presentment for the amounts as accredited.
Thank you, Your Honor.
I'm going to give you an email address where you can email that if you wish, counsels, you want to take it down. That's Carmen is the first name, Carmen dot, last name is Banks, Carmen dot Banks. Carmen is CARMEN, Carmen dot Banks at 36360 36 District Court.org.
Okay.
Now,
Thank you.
Thank you, Counsel. As it relates to Ms. Chappelle, ma'am, I'm going to reset this motion for hearing, and I'm going to set a date on this. I'm going to require that counsel direct a copy of this to you at the Tracy address. You're still living on Tracy, ma'am?
Yes.
Okay. I'm going to order that they send it to you on Tracy, and so they have to make sure that they get that to you not later than the 13th of January, and I will hear that on the 2nd of February. So your next date that you're coming back before me is going to be February 2nd, 2023, and that's going to be at 9:45 a.m. February 2nd, 2023, 9:45 a.m. The court's going to send you another notice out, Ms. Javelle, and counsel is going to send you a copy of the motion that they intend to advance in this case. Let me look at one other thing here. Just a second.
Thank you, Your Honor. Is there anything else?
Just one moment, counsel.
Sure.
All right, yeah, very well. I just want to make sure that certain other information was in the court's file. All right, so Mr. Chappelle, you received a notice of that next date, and counsel's office is going to send to the Tracy address the motion for summary disposition. You'll have an opportunity to answer it between the 13th and the 2nd of February, and then I will hear it and decide the outcome as it relates to you in this regard. All right. Thank you, Mr. Chappelle, and good day to you, man. Thank you, counsel. Good day to you, sir.
Thank you very much, Your Honor. Have a nice day. Goodbye.
And counsel, Brad, I ain't gonna try to touch your.
Yana Lunas, Your Honor, Yana Lunas.
Which matter are you here on?
So we were told, all right, so I have a motion to compel and a motion to adjourn up in case number 22-192999 GC. It's Wendy King, the plaintiff. We were advised by the clerk to go to the Zoom room. Judge Giles handled the original pretrial in our case, and So I know you weren't the presiding judge for that. So I'm not sure if there's a mix up or you're gonna hear the motion.
All right, it's the other Coleman. And there's a judge, Alicia Coleman. She's
Oh,
in she's in Zoom 534. So you're gonna go 360-534-0000.
all right. Thank you, Your Honor. Sorry for the mix up.
All right, not a problem, sir. Good day to you.
All right.
Good morning, Mr. Cray. How can we help you? Can you hear the court?
He's not, his audio is not connected. You doing a chat, are you?
Okay, I'm gonna go downstairs and check. Okay, on that one, with Jasmine Chappelle,
Okay,
in your order, I need you to put on there to add her to the, case, because she's not a party on the case.
she's answered. She's out and answered.
I know, but they don't have, that's why I printed that ROA. They didn't include her as a party. It's just one defendant.
Okay, so what I was going to do is I was simply going to set the motion hearing.
Yeah, so I can add her to the case,
All right,
and I update with the address.
gotcha. Perfect.
Alrighty, I'm going to go down here.
What happened to Mr. Craig?
Oh, I think he logged off and logged back in. He's having trouble.
Mr. Balzan, what's going on, sir?
Your Honor, I'm just a little bit confused today. I'm supposed,
Here.
yeah, Happy New Year. This case, Wendy King, it was in front of Judge Nance.
Okay.
but I got notice, and your Zoom was on the notice hearing, but I think it's with Judge Robinson. I'm very confused.
Yeah, that's,
What's the case?
what's the case number? Let's take a look at it, Mr. Thompson.
The case number is 22-192-999-GC.
Oh, I think that's it. That's with Judge Coleman. Just 1 second. There's a new Judge Coleman on this dock, Alicia Coleman, I think.
Yeah,
That's right.
Zoom number 534-360-534.
Zoom number 534. So,
So, can I get the full Zoom number? Because it's not on the website yet.
not problem. 360 534 and you're 0000.
Thank you so much.
That's Judge Jones Coleman.
Thank you so much.
She's new to this docket, so you'll be coming across. Unfortunately, now every time you hear Coleman, it won't necessarily be me. All right.
Thank you. Thank you for your time.
Yes, sir. All the best.
Thank you.